Okay, so imagine this. You're at a flea market, right?
Okay.
And you find a vintage Superman comic,
Uh-huh.
first edition, mint condition, like it is your holy grail.
Oh, the thrill of the hunt. Right.
Exactly. But the price tag just says best offer.
Oh, boy.
So you and the seller, you're going back and forth, you finally shake hands on a price, but then doubt creeps in.
Yeah.
Did you just agree to pay way more than you can afford?
Oh.
That, my friend, is the treacherous terrain of indefinite agreements.
Yeah, it's surprisingly common. People enter into agreements all the time without nailing down all the specifics.
Really?
Luckily, both common law and the Uniform Commercial Code, UCC for short,
Okay.
provide a framework for navigating these situations.
UCC, it's like a contract life preserver.
Precisely.
Hmm.
Especially for agreements involving the sale of goods. See, the UCC recognizes that sometimes you need flexibility, so it steps in when those contract details get a little fuzzy.
So let's lawyer up and more, let's figure this out.
You could say that,
Yeah.
but it's not a free-for-all. The UCC has specific provisions that come into play.
All right, let's dive into those provisions.
Okay.
I see we've got sections on open price terms, variations by agreement, even where and when delivery should happen. Sounds like my last attempt at baking a cake, just lots of improvisation.
And probably just as messy,
Yeah.
but that's where the UCC steps in to provide some structure. Let's start with UCC 2305, the open price term.
Okay.
Remember that comic book scenario? Let's say you and the seller never actually agreed on a specific price, just that you'd work it out later.
Oh boy, that's a recipe for disaster, right?
Not necessarily. Under 2305, as long as you both intended to make a deal, the contract could still be valid.
Really?
The UCC would step in and say a reasonable price should be determined at the time of sale.
So no more frantic eBay searches to prove you're not getting ripped off.
Well, you can still do your research.
Yeah.
But the key is that both parties acted in good faith, meaning no wildly inflating prices or trying to pull a fast one.
Right.
Now imagine you and that comic book seller decide to make things a bit more interesting.
Oh, I do love a plot twist. What did they cook up?
Let's say you both agree to abide by a special rule. Whoever can hold their breath the longest gets a 10% discount.
Wow.
That's where UCC 1302, variation by agreement, comes in.
Okay.
It allows you to modify the UCC's rules as long as those modifications are reasonable and don't violate basic principles of fairness and honesty.
So a breath-holding contest, total legit,
Right.
trying to slip in a clause that says all sales final, even if the comic turns out to be fake? Not so much.
Exactly. You can't just erase fundamental obligations like acting in good faith or dealing fairly.
Makes sense. Now, where does this epic comic book exchange go down? We're talking delivery logistics.
Excellent question. And that's where UCC 2308, dealing with the absence of a specific place for delivery, comes in.
Okay.
If you don't specify a location, it's presumed to be the seller's place of business, unless you both know the comic book is stashed somewhere else, like a secret vault.
So no more awkward encounters at the local police station because you forgot to set a meeting spot.
Right.
Though, I bet there are some good stories there.
Perhaps another time. But let's say you're both so caught up in the excitement that you forget to set a specific time for the exchange.
Okay.
That's where UCC 2309 swoops in, addressing the absence of a specific time for delivery.
So no showing up at 3 a.m. demanding the comic.
Well, you could try, but it wouldn't be considered reasonable.
Right.
The UCC would say the exchange should happen within a reasonable time frame given the circumstances. It also clarifies that if there's no set end date for the agreement, either party can back out with proper notice.
Okay, so reasonable notice is key.
Yes,
You can't just ghost the seller after you've agreed to buy the comic.
precisely. You can't leave someone hanging without a good reason.
Yeah.
The UCC is all about finding that balance between flexibility and fairness, even when the initial agreement is a little vague.
Got it. So far, the UCC sounds less like a scary legal document and more like a helpful guide to navigating the sometimes confusing world of contracts.
That's a great way to put it. But it's important to remember that real-life contract disputes can be a lot more complex than trading comic books.
And I'm guessing that's where those real-life legal battles come in.
You're catching on quickly. Buckle up, because those cases will really make you think twice about the agreements you make.
All right, hit me with those real-life contract dramas. What kind of cases are we talking about?
Get ready for some juicy legal showdowns. We've got Varney v. Ditmars, Oglebay Norton v. Armco, and Blinn v. Beatrice Co. Each one highlights a different wrinkle in the world of indefinite agreements.
Okay, lay it on me. Case number 1, Varney v. Ditmars. What went down there?
Picture this. It's 1916 and we're in New York. An ambitious draftsman named Mr. Varney gets a sweet job offer, a fair share of the company's profits on top of his regular salary.
Sounds like a pretty good deal. Who
Yeah.
wouldn't want a slice of that profit pie?
Right. But that's where things get messy. See, fair share wasn't exactly defined in the agreement.
Oh,
Fast forward, Mr. Varney gets fired, and naturally he wants his fair share.
I can see where this is going. Lawsuit time.
You got it. Mr. Varney sues, but the court sides with the employer.
Really?
Why? Because the term fair share was simply too vague to enforce. The court needed something more concrete, something measurable.
So even though there was an agreement in principle, the lack of clarity about what constituted a fair share made it unenforceable.
Exactly. It's like saying, I'll bake you a huge cake. What does huge even mean? 1 tier? 3 tiers? A cake the size of a small car. You need specifics.
Okay, lesson learned, specificity is key. Now on to case number 2. Oglebay Norton v. Armcom. This one sounds a little more industrial strength.
We're talking big business now, long-term contracts for shipping iron ore. The kind of deals that involve giant ships and even bigger price tags.
I'm guessing fluctuating prices were at the heart of this dispute.
Bingo. The contract didn't clearly outline how prices would be adjusted over time, and as you can imagine, that caused some major friction between the companies involved.
Okay, this sounds a bit like Varney v. Ditmars. A lack of clarity about key terms. So why didn't the court just throw out this contract too?
Here's the difference in Oglebay. It was clear that both parties intended to be bound by the contract. Plus, they had a history of working together and had established mechanisms for figuring out a reasonable price.
So the court saw a way to salvage the deal and make it work.
Precisely. They recognized that long-term agreements often need some flexibility to account for market changes. But the intent to be bound by the agreement was crucial. Now brace yourself, because our final case, Blinn v. Beatrice Company, takes us to the land of verbal promises and workplace drama.
Ooh, this I gotta hear. Tell me more.
Imagine you're Mr. Blinn, a dedicated employee who's considering a career move. You go to your boss, express your concerns, and he reassures you saying, we have at least 5 more years of work to do.
Okay, I've been in that situation. You hear those words and you breathe a sigh of relief.
Right. You trust your boss, so you pass up the other job offer and keep pouring your heart and soul into your current job. But then plot twist, a few months later, you're let go.
Oh no, that's rough. So did the court consider that verbal promise a binding contract?
Here's where it gets really interesting. The court said, not so fast. While the boss's statement was definitely promising, it wasn't specific enough to be considered a formal contract. However, and this is important, they did find that a concept called promissory estoppel came into play.
Promissory estoppel sounds like a legal tongue twister. Break it down for me.
In a nutshell, it means that even if a promise doesn't check all the boxes of a formal contract, it can still be enforceable if one party relied on that promise and suffered a detriment as a result.
So even though the boss didn't make a legally binding contract, he still couldn't just go back on his word because Mr. Blinn had relied on his promise to his detriment.
Exactly. The court recognized that Mr. Blinn had reasonably relied on his boss's statement and had given up other opportunities because of it. He was in a vulnerable position, and the court aimed to make it right.
Wow, these cases really highlight the nuances of agreements and the importance of clear communication. It seems like there's a fine line between flexibility and leaving yourself vulnerable to misunderstandings.
You've hit the nail on the head. It's all about finding that balance between wanting flexibility in our agreements and also needing enough clarity to avoid confusion and potential disputes.
So what are the key takeaways here? How can we navigate this tricky world of indefinite agreements without accidentally ending up in court ourselves?
Great question. I think there are a few things to keep in mind. First and foremost, clear communication is crucial. Don't be afraid to ask questions, clarify expectations, and put things in writing whenever possible.
Basically, channel your inner lawyer a bit, even if you don't have the briefcase and fancy shoes.
Exactly. And don't rely on assumptions.
Right.
Just because something seems obvious to you doesn't mean it's obvious to the other party.
It's like my grandma always says, assumptions are the termites of relationships. Not sure where she picked that one up, but it's certainly stuck with me.
Wise words. And finally, know when to seek professional legal advice. If you're dealing with a particularly complex or high-stakes agreement, it's always best to consult with an expert who can help you dot your I's and cross your T's.
Couldn't agree more. It's better to be safe than sorry, especially when it comes to legal matters. Now, this whole discussion about indefinite agreements, it reminds me of a situation I encountered recently.
Yeah.
Imagine you're at a bustling flea market
Oh,
and you come across a vendor selling vintage comic books.
I'm intrigued. Tell me more.
Okay, so I'm walking down the rows and I see this rare issue of Amazing Fantasy. You know, the one where Spider-Man makes his first appearance?
Oh, wow, yeah. I bet the price tag on that was anything but indefinite.
You would think so, right?
Yeah.
But it gets even more interesting. There was a price tag, but it was handwritten and barely legible.
Oh, no.
And there were these two other collectors huddled around debating the price, throwing out
A
numbers.
bidding war.
Oh, yeah. It was fascinating to watch. Each collector thought they had an agreement with the seller, but no one was quite sure what they were actually agreeing to.
Wow.
And it just reminded me that even in a casual setting like a flea market, those indefinite agreements can lead to so much confusion and even conflict.
Yeah, definitely. It all comes back to clear communication being crucial no matter the size or scope of the agreement.
Well, after this deep dive, I'm definitely going to be more mindful about dotting my I's and crossing my T's, whether I'm haggling for a comic book or just making plans with friends.
That's the idea. Understanding the basics of contract law, especially those tricky indefinite agreements, really empowers you to protect yourself and ensure everyone's on the same page.
Absolutely. Well said. It's been fascinating exploring these real-life legal battles, unpacking the UCC. Who knew that contract law could be so captivating?
It's all about making those connections to everyday situations. And who knows, maybe our listeners will start spotting indefinite agreements everywhere they look.
Now that you mention it, I have a feeling our listeners will never look at a handshake agreement the same way again. For everyone listening, be sure to check out the show notes for more information and resources on indefinite agreements and the UCC. And until next time, remember, clarity is key, and when in doubt, don't hesitate to seek expert advice. Happy contracting.